Good evening, everyone, and on behalf of the partners of King & Wood Mallesons, I'm very pleased to welcome you to the 2020 Castan Centre Annual Lecture. My name is Ben Kiley. I'm a partner of King & Wood Mallesons, practicing in the dispute resolution team. Firstly, on behalf of the firm, I begin by acknowledging the traditional owners of the many lands on which we meet, and I pay my respects to their elders past, present, and emerging. Mallesons is pleased to present this lecture in partnership with Monash's Castan Centre. As many of you will be aware, the Castan Centre is celebrating its 20th anniversary this year. At Mallesons, we're very proud of the relationship that we formed with the Centre during that time, including the joint presentation of this annual lecture for over 13 years. Despite its online format this year's lecture continues to be an important opportunity to hear from high-profile speakers as they share their thoughts on key human rights issues. King & Wood Mallesons is a top 10 global firm, with over 2,400 lawyers in 28 locations around the world. In our Australian offices, we have a long and proud tradition of upholding and defending human rights through our pro bono and community impact programs. This program deploys Mallesons' expertise, experience, and networks in a highly strategic and multi-layered approach to reduce inequality and poverty among young people, especially First Nations young people. In addition, we're the only law firm in Australia with a dedicated human rights law group, which allows our partners and lawyers to apply their significant expertise in advocacy and their understanding of justice and human rights issues to help those most in need. This year, the firm won Pro Bono Program of the Year award in the Lawyers Weekly Australian Law Awards. In the last financial year, we provided 51,292 hours of pro bono legal services across all of our pro bono client groups. First Nation clients received the greatest share of these services, something we're very proud of at this firm. We've also launched our third and most recent Stretch Reconciliation Action Plan in June, which embodies our commitment to strive for better reconciliation outcomes for all Aboriginal and Torres Strait Islander peoples. Our esteemed speaker this evening, Professor Davis, is an external consultant of Mallesons as part of our reconciliation and empowerment leadership group, and she provided her expertise in drafting our Stretch Reconciliation Action Plan, and we're very grateful for it. Dr. Briggs will give Professor Davis a proper introduction in just a few minutes, but before then, and without further ado, I'd like to introduce Professor the Honourable Kevin Bell, the newly appointed Director of the Castan Centre for Human Rights Law. A leading human rights jurist, Professor Bell served as a Justice of the Supreme Court of Victoria between 2005 and 2020, and wrote a number of leading judgments in relation to the Charter of Human Rights. In 2017, Professor Bell was made a member of the Order of Australia for significant service to the law and to the judiciary, to native title, human rights, and the community. Congratulations on all your work so far with the Castan Centre in its 20th year, and over to you, Professor Bell.
Ben, thank you very much for that warm introduction. I really appreciate it. It's a delight to be here, particularly in our 20th anniversary year, and particularly in relation to an important subject such as this. Can I pay my respects to the elders past and present of the traditional owners of the land where I now sit. Those elders are in fact present today. Auntie Carolyn Briggs is one of them. The Boonwurrung people of the Kulin Nations are the traditional owners of the land where I am. I'm aware that there are many other traditional owners in lands where others speak. So I want to go forward now and to introduce Auntie Carolyn Briggs, who's well known to me over a long period of time. I was just speaking to Auntie Caroline about starting university in the early 70s. I started in the mid-70s. I was not far behind you, Auntie Caroline. Awi, her traditional name, Dr. Caroline Briggs, is a Boonwurrung senior elder and the chairperson and founder of the Boonwurrung Foundation. She's a senior Indigenous research fellow at Melbourne University, recently graduated as a PhD, and a graduate research supervisor at Monash University. Before asking her to introduce our very distinguished speaker, Professor Megan Davis, I want to say that Professor Davis's lecture has been announced in relation to its topic, and that is the topic of the state of Indigenous peoples' rights in Australia, the Universal Declaration of the Rights of Indigenous People and the Uluru Statement from the Heart. Might I also acknowledge the presence in the audience today of Professor Jacinta Elston, who is an Aboriginal woman from Townsville in Northern Queensland, and the inaugural Pro-Vice Chancellor Indigenous at Monash University. I will now hand over to Boonwurrung Senior Elder, Dr. Carolyn Briggs AM, in order to introduce Professor Megan Davis. Thank you, Auntie Caroline.
Nongujin, I'm very honoured to be able to be a part of this 20 years of inaugural presentation of the Castan Centre, and also I pay my respects to you and all the people that are a part of this launch tonight. And I also would like to pay my respects, and it's that to introduce and take my pleasure to introduce Professor Megan Davis this afternoon. Professor Davis is from the Gobble Gobble Aboriginal Women of Berrigum Nation of Southwest Queensland, and is also of the South Sea Islander descent, Vanuatu. She grew up in the Queensland in North Burnett region. She's a Pro-Vice Chancellor, Indigenous, and a Professor of Law at the University of New South Wales. She is also an Acting Commissioner of the New South Wales Land and Environment Court, and was recently appointed to the Bernard chairs in the constitutional law, and admitted as a solicitor of the Supreme Court of the ACT and a fellow of the Australian Academy of Law. Professor Davis is a constitutional law professor specialising in constitutional design and constitution building. And she is one of the nation's leading public constitutional lawyers. She is a member of the Referendum Council and an expert panel on the recognition of Aboriginal and Torres Strait Islanders peoples in the Constitution, and was an expert member of the United Nations Permanent Forum on Indigenous Issues. Is currently a member of the United Nations Human Rights Council, an expert in the mechanics on the rights of Indigenous expert mechanism on the rights of Indigenous people. And in 2018, Professor Davis was named an overall winner of the Australian Financial Review 100 Women of Influencers Award. She is also a commissioner of the Australian Rugby League Commission. And Professor Megan Davis will talk on the subject related to the human rights of Indigenous peoples. So I'd like to take this opportunity of welcoming Wominjeka. Your purpose for coming is to celebrate the 20 years of the Centre, the Castan Centre in Law. So it's our opportunity at Monash University to present Professor Megan Davis. Nongujin.
Thank you very much, Dr. Briggs, for that beautiful introduction. I really appreciate it, and it's certainly an honour to be introduced by someone of your distinction. So thank you. It is an honour to have been asked to speak tonight and deliver the Castan Centre and King and Wood Mallesons annual lecture. As Kevin said, I'm going to talk about the state of Indigenous rights, the UN Declaration on the Rights of Indigenous Peoples and the Uluru Statement from the Heart. The Castan Centre for Human Rights is one of the most important human rights centres in Australia today, and I've been an academic probably for 20 years now. and it's always played a really important role in human rights law in Australia. And I wanted to acknowledge, the work of Ron Castan in particular, who was one of Australia's greatest human rights jurists, and in particular a pioneer in the field of Indigenous people's rights. And just wanted to give a shout out to Professor Bell, who I've had a number of yarns with over the years about constitutional recognition on this very lengthy decade of constitutional recognition that we've all been embarking upon. And it's really important to have, those key figures in the profession who you can have these conversations with and who support such work. And to that end, I just wanted to thank Ben as well. The King and Wood Mallesons has been a really great supporter of my work, and I feel very privileged to be a part of their RAP group. But in particular, when the Uluru Statement from the Heart was issued as an invitation to the Australian people, we're really proud that so many Australian law firms, global Australian law firms, stood up to the plate and accepted that invitation, because it set an example to the rest of the nation. And King and Wood Mallesons is one of those firms who stepped up. And to that end, I just want to also note the incredibly important and generous role Dan Creasy from KWM has played in the work of the Uluru Dialogues and the work of the Indigenous Law Centre at UNSW, who does a lot of the constitutional work around Uluru. So I feel I was very honoured to be invited to give this lecture tonight because of those connections that I do have, very authentic connections to both the Castan Centre and the firm. So thank you. So as I said, I'm going to speak about the UN Declaration on the Rights of Indigenous Peoples and Indigenous Rights and the Uluru Statement from the Heart. And I mean, it's fair to say I've spent a lot of time in the past 5 to 10 years, if not longer, on constitutional reform. But I do have, a day job. And to that end, I should say hi to Jacinta as well. Hi, Jacinta. Jacinta is my PVCI colleague. So it's nice to hear that she's, online. But apart from my day job, like Jacinta is the Provost Chancellor Indigenous, I do have a parallel career with the UN. So for the past 2 decades, I have been an international human rights lawyer who has participated at the United Nations in many ways. For the past decade, certainly as a formal UN expert, but prior to that, I've participated as a lawyer. And in particular had the great privilege to participate in the drafting of the United Nations Declaration on the Rights of Indigenous Peoples. So I know the declaration really intimately, and it's been, a great honour to not just participate in that, but to see it adopted by the General Assembly, and in particular the work of Les Malza, an Australian Aboriginal man, was really key to that adoption by the General Assembly, to see Australia eventually endorse it, but to see its work and what it is intended to do to come to fruition through the UN system. So for the last decade, I have served, and they are very lengthy titles, as Caroline noted when she was reading them out, the UN Permanent Forum on Indigenous Issues, which is based in New York under the Economic and Social Council. And I served on that body for 6 years. But I have now served 1 term and undergoing my 2nd term as an expert of the Human Rights Council on the expert mechanism on the rights of Indigenous peoples in Geneva. So it's really that role I kind of want to touch upon tonight as I talk about the Declaration and Uluru, because the expert mechanism brings with it a kind of new and updated mandate that was granted to the expert mechanism by the UN General Assembly after the World Conference on Indigenous Peoples. And this new mandate was to and is to really ramp up the state's implementation of Indigenous peoples' rights under the UN Declaration on the Rights of Indigenous Peoples. So our new mandate as an expert mechanism is to assist member states in achieving the goals of the UN Declaration. So we do things like studies to advance the promotion and the protection of Indigenous people's rights. And we do that to clarify key principles. So we've published a new study on free, prior and informed consent to clarify what that means. There's a lot of reinterpretation, creative reinterpretation of the Declaration on the Rights of Indigenous Peoples post its adoption. And another key principle that we are just clarifying for the world's Indigenous peoples and UN member states is the right to self-determination. And I'll turn to that in a moment, because there's a lot of creative reinterpretation of this right to self-determination by Australian governments currently, and it's not what the right to self-determination really is. Another core part of our mandate is examining good practices, and so part of that involves us doing country visits as an expert mechanism to particular countries. But also we visit countries at the request of member states or Indigenous peoples to attend a particular country and help mediate or resolve particular issues. So we've done a number of really interesting in-country visits, such as to Finland when the Finnish Parliament was amending the Sami Parliament Act, so the Electoral Act, which determined who could vote in Sami elections. So the Sami Parliament in Finland is somewhat like our what a voice to Parliament would be, that is being advocated under the Uluru Statement. So that's part of the work that we've done. We also are brought in to resolve and mediate some issues between member states and Indigenous peoples, and have just recently resolved successfully a dispute over a mask that the Swedish Museum held that we had returned to its rightful owners in Mexico. So it's very interesting work, and intellectually certainly some of the most difficult work that I've done at the UN, and particularly because we are now looking at the implementation of the right to self-determination, which is really the normative key norm that drives the framework of the right to self-determination. So really the thesis of my annual lecture today is to say a few things. One thing really is to say, when we take a ruler and we look at the UN Declaration on the Rights of Indigenous Peoples, there's a plausible argument to be made that a large percentage of the rights embedded in the Declaration may, in Australia, meet the threshold of a minimum standard. We know that those standards are shaped in the Declaration around a number of themes. And those core themes are the right to self-determination, life, integrity and security, cultural, spiritual and linguistic identity, education, informational and labour rights, participatory rights and economic and social rights, lands, territories and resources. And then the tail end of the Declaration is about the exercise of the right to self-determination. So an audit of that framework might suggest that Australia meets in certain parts of the minimum standard. But what I want to really stress in this annual lecture tonight, that what is patently obvious to any expert at the UN level, and certainly to anyone really participating at that UN level, is that Australia does lag behind when it comes to the recognition and implementation of the right to self-determination, and in particular, the really key provisions relating to political participation. And with my UN hat on, it's really clear that we do lag behind many countries on this, who have taken a lot of effort to develop mechanisms and structures, constitutional rights, to enhance Indigenous peoples' participation in their democracy. So, you know, we are falling behind on that. And there's all sorts of reasons for that. When I reflect on my 2-year inquiry into New South Wales Aboriginal out-of-home care, what I did find was that the state was using the language of the right to self-determination, but not using it in the way in which it is intended to be. So, for example, the removal of a child from an Aboriginal family, the notion that the signatory to that removal is an Aboriginal person under in an organisation that is created under, you know, a statutory framework that creates Aboriginal organisations. The claim that that is the right to self-determination, or the exercise of the right to self-determination, is simply not the case. And there's many policy areas across the Federation where the right to self-determination is being incredibly and increasingly redefined. And I think the most recent report of the UN Special Rapporteur following her visit to Australia really demonstrates that. She singles out multiple sites that are problems for Australia in terms of Indigenous rights in Australia. She singled out the fact that we don't have substantive human rights protections in Australia. She singled out the Indigenous advancement strategy and the closing the gap strategy. She singled out our access to education for Indigenous peoples, health services, unemployment and housing shortage. She singled out the compulsory income management schemes in various iterations across the Federation. And of course, incarceration and the administration of justice, the removal of children from their homes, violence against women, and of course, political participation. And in her most recent report, she identifies all of these ways in which the Australian state is failing to recognise and accommodate the right to self-determination within the Australian system. She says that stark disparities and social disadvantage persists between Indigenous and non-Indigenous Australians across all quality of life indicators, and that Indigenous Australians generally experience significantly lower standards of health, education, employment and housing, and are drastically overrepresented compared with non-Indigenous people in the criminal justice system, among children and out-of-home care, and among family violence victims. And she regrets that her report and the indicators that she singles out had deteriorated significantly since her predecessor's visit. And this is despite the kind of numerous innovative solutions that Indigenous communities come up with that remain underfunded. So really, one of the key things that we're seeing, both in the Universal Periodic Review, in treaty reports, and in the Special Rapporteur's reports, insofar as Australia and the situation of Indigenous peoples in Australia, is that we fare poorly in the implementation of the Declaration on the rights of Indigenous peoples because we fail to implement the core political rights in the Declaration that would have our people at the table. And notably, and I'll return to them later, Articles 18 and 19 of the Declaration that really provide important procedural guarantees for Indigenous peoples. Article 18 of the Declaration recognises the right of Indigenous peoples to participate in decision-making in matters that affect their rights through representatives chosen by themselves in accordance with their own procedures, as well as to maintain and develop their own Indigenous decision-making institutions. And Article 19, it requires the states to consult and cooperate in good faith with the Indigenous peoples concerned through their own representative institutions before adopting and implementing legislative and administrative measures that may affect them. Now, we all know this year from multiple examples, and in particular you can Gorge, that this doesn't happen. And we know 3 years post the Uluru Statement from the Heart and the advocacy for an enshrined right of political participation, that this is not happening. We are not being consulted in good faith before they adopt and implement legislation and administrative measures that affect our people. So that's really, I think, a really important message to keep in mind when we reflect upon the current reform agenda in Australia. The Declaration on the Rights of Indigenous Peoples is a really important yardstick for us because it is a non-binding declaration of the General Assembly. And it's a framework that states can adopt in their relationship with Indigenous peoples and can guide them in the development of domestic law and policy. And this is a really key thing because this is the Declaration on the Rights of Indigenous Peoples was used as the benchmark and yardstick to design the Uluru constitutional dialogues. And it was also used to determine the guiding principles that were adopted at Uluru that would help frame negotiations with the state when it comes to what the reform looked like post-referendum council. So the declaration does play that really important normative role in framing in a very kind of objective and independent way through a lens that has been adopted by a system that we have signed up to and we participate in, the United Nations. And given the authority of the General Assembly under the Charter of the United Nations. So it is an important declaration. It does have normative significance and it has important legal obligations for Australia. So what I wanted to turn to then is how the declaration was used in the context of decision-making around the Uluru Statement from the Heart, because it is something not often discussed or referred to. The first thing that I wanted to, I suppose, point out is just to reiterate what I said from the start. The declaration is made up of clusters of rights. So all of the rights contained in the declaration are held under in thematic sections. And the one important way to look at the declaration and how we use it as Indigenous peoples in particular is that it sets out what the right to self-determination looks like when it is exercised and when it is implemented. And a key factor or characteristic of the declaration that, again, too many governments forget is that it is a collective rights instrument, because Indigenous peoples are a collective culture. And that is absolutely critical to understanding Indigenous peoples and Indigenous peoples' rights. So Article 18 and Article 19 very much helped shape the way we on the Referendum Council thought about how to engage communities on constitutional recognition and what is meaningful constitutional recognition to communities. And as many people know, the outcome of the Referendum Council's work and the constitutional conventions that were held was a framework of reforms known as Voice Treaty Truth. In effect, we were asked a single question by the federal government or the Commonwealth when the Referendum Council did its work, and that is, you know, we're going through this kind of decade period. It is 10 years this year of 5 processes and 8 reports. And the question of the Referendum Council was, what form of recognition do Indigenous people support? And so that is the question that we asked people in that process. What is meaningful recognition to you? And we set out all of the reforms that Turnbull and Shorten had agreed to. Now, the most highly prioritised unanimously across all dialogues was this voice to Parliament. And I think the constitutionally enshrined voice to Parliament really speaks to the powerlessness and voicelessness that people feel in this contemporary iteration of Australian law and policy insofar as Indigenous people's rights. And I think writing at the time, commentators, well, not commentators, but important, I think, statesmen like Fred Chaney and the Social Justice Commissioner like Mick Gooder, they were writing at the time that the conditions, the policy conditions of 2015, 2016 were some of the worst that they'd ever seen in Australian policy. So it's really important to understand that when we contemplate why it was that a constitutionally enshrined voice, so a mandated seat at the table, was the reform that attracted people the most as being meaningful constitutional recognition. So we put the UNDRIP front and centre of the work that we did. But what's less known is that at Uluru, what was agreed to and developed was a series of guiding principles that should help frame and fence negotiations with the government. And these guiding principles are imbued with the UN Declaration on the Rights of Indigenous Peoples. And that was important to virtually every community that we spoke with. And this even predates the Referendum Council, even the expert panel set up by Julia Gillard on the recognition of Aboriginal and Torres Strait Islander peoples in the Australian Constitution had as its yardstick the Declaration on the Rights of Indigenous Peoples. And that's because these are international standards that our people contributed to. There were many Aboriginal and Torres Strait Islander peoples that participated in the drafting of the Declaration. The Declaration is imbued with some really fundamental policy principles that were innovated or created in Australia as an Australian innovation. For example, the concept of community control. For example, the notion of a veto right when it comes to land rights and territories and resources. So there were, and also ATSIC. So Article 18 and 19 were very much, I think, influenced by the participation of the Aboriginal and Torres Strait Islander Commission at these meetings. So these guiding principles we distilled from the Bark Petitions, the Barunga Statement, the Eva Valley Statement, the Kalkaringi Statement, the Social Justice Package, the Kirribilli Statement, and the UN Declaration on the Rights of Indigenous Peoples. And those 10 principles are that any assessment of reform proposals could only proceed, the option could only proceed if it did the following: if it did not diminish Aboriginal sovereignty and Torres Strait Islander sovereignty, if it involved structural and substantive reform, if it advanced self-determination in the standards established under the UN Declaration on the Rights of Indigenous Peoples, if it recognised the status and rights of First Nations, if it tells the truth of history, if the reform does not foreclose on future advancement, if the reform does not waste the opportunity of reform, and I think that really speaks to the wholesale rejection of constitutional symbolism, which looks good and is symbolic, but is wasting the opportunity of structural reform. If the option number 8, principle number 8, if the option provides a mechanism for First Nations agreement making, if it has the support of First Nations is number 9, and number 10, it does not interfere with positive legal arrangements. So I just want to point to the principles that were imbued with the UN Declaration on the Rights of Indigenous Peoples, because I think it's important to understand the principled human rights approach of decision-making around the Uluru Statement from the Heart. Principle 2, that the reform needed to involve substantive and structural reform. I mean, this is consistent with Aboriginal advocacy for reform for a very long time. And we, cited many Aboriginal statements for reform, that it must be substantive, that it must not be minimal or symbolic, that wasn't enough. And that's consistent with the Kirribilli statement in 2015 that said any reform to the Constitution must involve substantive changes to the Constitution, and that a minimalist approach that provides a preambular recognition, removes Section 25, and moderates the race power does not go far enough and would not be acceptable to Aboriginal and Torres Strait Islander peoples. And this was said in 2015, 2 years before Uluru. So the approach has been, the approach of First Nations people has been utterly consistent across the years. But this second principle is very much imbued with Article 3 of the Declaration, the right to self-determination, that Indigenous peoples have the right to self-determination, and by virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. The other right that Principle 2 is imbued with is the provision in the United Nations Declaration on the Rights of Indigenous Peoples that says that Indigenous peoples have the right to the recognition, observance, and enforcement of treaties, agreements, and other constructive arrangements concluded with states or their successors, and to have states honour and respect such treaties, agreements, and other constructive arrangements. And that's an important point, because the second reform in the Uluru framework is treaty, it's agreement making. And agreement making has been a primary aspiration of Aboriginal people for a very, very long time. And so Principle 2 is very much imbued by self-determination as a political right, and also the right to have treaties, agreements, and constructive arrangements as enlivened by the Declaration. Principle 3 advances the right to self-determination, but generally the DRIP. So, of course, Principle 3 is imbued with the DRIP. But it's important that sitting under it is a clear commitment and advocacy for the right to self-determination, not as the state currently interprets it or misinterprets it, but as it is enshrined in Article 3 under UNDRIP. And we cited multiple other statements in history where our people, our First Nations peoples in various parts of the country altogether have advocated for the recognition of self-determination, including the Barunga Statement in 1988, and of course the Social Justice Package, which was one of the fundamental principles underpinning VAT. And if you all recall, the Social Justice Package was the third arm of the native title settlement that has not yet been implemented. So when the native title, when the High Court handed down the Mabo decision, the response was to do three things. One was to provide the statutory framework for people to claim native title and seek a determination. The second was to compensate those who had been dispossessed and would not be able to claim native title status. And the third was the social justice package that comes along with a High Court decision like that. What does settlement look like to our people? So ATSIC did a huge amount of work consulting around the country with communities on this social justice package. and it wasn't and still remains unimplemented. Principle 4 of the guiding principles of the Uluru Statement from the Heart recognises the status and the rights of First Nations peoples. And I think this was a really key point that is often overlooked when people talk about the Uluru Statement from 3 years ago, and that is the right to have our collective rights respected. So the Barunga Statement had called for the government to recognise our rights to respect for and promotion of our Aboriginal identity, including the cultural, linguistic, religious and historical aspects, and including the right to be educated in our own languages and in our own culture and history. And again, one of the fundamental principles that underpinned ATSIC's work on the social justice package in response to Mabo was the recognition of Indigenous peoples' status as the original owners of this land and of the particular rights that come with that are associated with that status. And this is consistent with Article 3 of the Declaration on the Rights of Indigenous Peoples, but also the very important preambular statement of the UN Declaration that was agreed to by the General Assembly, and that is the urgent need to respect and promote the inherent rights of Indigenous peoples which derived from their political, economic and social structures and from their cultures, spiritual traditions, histories and philosophies, especially their rights to their lands, territories and resources. Principle 5 of the guiding principles of Uluru was that any reform must tell the truth of history. And we all know that the third component of the Uluru Statement is truth-telling. Truth-telling as an important process for the nation and for the relationship between First Nations people and the country. And so truth-telling as a guiding principle has again been drawn upon in many previous statements, such as the Eva Valley Statement post-native title, where it said that a lasting settlement must recognise and address historical truths. And the UN Declaration also enshrines the importance of truth-telling, and that's based on the UN General Assembly's resolution on the basic principles on the right to a remedy and reparation for victims of gross violations of international human rights law and serious violations of international humanitarian law. So in the work that the Referendum Council did and the dialogues that culminated in Uluru was very much grounded in the work of the General Assembly around remedy and reparations, but also the Human Rights Council's work on the resolution of a right to the truth, where victims of gross violations of human rights should know the truth about those violations to the greatest extent practicable. And that states should provide effective mechanisms to make the truth known for society as a whole, and in particular for the relatives of victims. So Principle 5 is also deeply embedded in this UN human rights framework. The final two principles that the Uluru Guiding Principles embed is Principle 8, that any reform must provide a mechanism for First Nations agreement making. And I think everyone agrees to the importance of agreement making mechanisms, and that is reflected in the DRIP and in particular in Article 37. And I think it's important to keep in mind that the appetite for a treaty right now really depended on what region or area you lived in the country, And it was really informed by the level of community participation in native title processes. So in some places where native title was very prominent and there were large determinations of native title, there was more fatigue with agreement making than in those areas where there were no, there is not substantive amounts of agreement making. So it really depended on how strong your land rights are currently recognised as to your appetite for entering into treaties. And that's for a number of reasons. One is a deep concern in the community that there is a need for dispute resolution services for communities to heal, because many families and communities have been ripped apart by the native title process. So there was a deep concern about that, as well as a very strong sentiment that our people, our First Nations, needed to enter into treaties with each other first, that we needed to learn how to work together and talk together and respect each other first before contemplating entering into these complex legal negotiations with the state. And then the other thing that really I think influenced this is the need for some sort of constitutional basis or constitutional hook in which treaties can cascade or agreements can cascade off. And the recognition of an Indigenous voice is really important to have that structural power addressed in the Constitution. So the final principle before I wrap it up is that the reform must have the support of First Nations. And so this seems, Principle 9 seems like a pretty obvious point, but I'm not sure the nation is really as cognizant of the lack of consultation of people affected on many laws and policies over the years. I'm not sure that the nation really understands just how poorly that has happened, because it's a consistent theme, not just for us in Australia as First Nations peoples, but globally, because it's a power issue. It's a power issue, which partly informs the constitutional enshrinement argument of the voice, is that they're not going to have us at the table out of the goodness of their own heart. I mean, even when they did the West Australian Cultural Heritage Amendments, they weren't privileging the participation of traditional owners by any stretch of the imagination. And people are shocked that there were no Indigenous hands involved in these consultations, but that is the level of that is the status to where that is where we are right now, and have been for some time. And so they won't bring us to the table out of the goodness of their own heart, because that's not how power structures work. But through a referendum by the Australian people, we can compel them to have us at the table. We can compel them to listen to what we have to say about laws and policies that impact upon us and our country and our cultural heritage. So the failure to consult, and this is why when you do the history on the Voice to Parliament, that the notion of an enhanced participation in the democratic life of the Australian state is as long as the advocacy for agreement making and treaty, because the failure to consult has been the theme of this nation when it comes to dealing with Indigenous peoples. And, some of the very first kind of activism at a federal level is around the failure to consult with First Nations. It's been, as we say in the Uluru Statement, a persistent cause of activism. Whether it's the 1963 Yirrkala Bark petition. There you have the example of the federal government excising their land without even undertaking consultation or seeking your new consent. They didn't speak to anyone. And so that example also permeates all of the kind of the lament people have about the very early Mabo decision and the response to the Mabo decision. The Eva Valley Statement did call for the development of legislation that would enable the full and free participation and consent of peoples concerned. So this idea for a voice to Parliament and this idea for us to be at the table has been around for a very long time, and very much supported by that framework, the normative framework of Indigenous people's rights in international law. I'm just thinking, Kevin, I should probably start wrapping up now. Yes, I'm getting the nod. So I'll move to my conclusion. I've already made the point that the most recent Special Rapporteur on Indigenous People's Rights report has found that although Australia has endorsed the declaration, Australia has not done enough to implement the right to self-determination as a fundamental element of the declaration. And that is whereby Indigenous peoples have the right to determine their political status freely and pursue their economic, social and cultural development freely, but also have the right to autonomy or self-government in matters relating to their internal and local affairs, as well as the state providing the ways and means for financing their autonomous functions. So she, in the most recent UN Special Rapporteur report on Australia, in-country report, she found that while Australia has adopted numerous policies aiming to address the socio-economic disadvantage of Aboriginal and Torres Strait Islander peoples, the failure to respect their rights to self-determination and to full and effective participation is alarming. And she says that failure in terms of self-determination and full and effective political participation has a compounded effect, and it contributes to failure, she says in her report, to deliver on the targets in the areas of health, education, employment, and closing the gap. And she argues has contributed to aggravating the escalating incarceration and child removal rates of Aboriginal and Torres Strait Islander children. So to conclude, I think that the most recent external assessments of Australia by UN bodies reinforces the understanding that we do have as First Nations peoples in Australia, that the state of Indigenous people's rights is deeply concerning. Nothing really has been done to arrest the regression that Cheney or Gooder referred to in 2015. Not 5 years later and not 3 years after the Uluru Statement from the Heart. And one of the fundamental elements of what the Uluru Statement from the Heart calls for or seeks to address is that structural powerlessness. It's that lack of public power that cannot be garnered at a state level, and it can't be garnered at a territory level. It can only be done at a Commonwealth level. And that's because of the way in which Australia's federation has developed over the century or so. And look, a lot of people will say, oh, look at Canada, look at the US. Canada has very strong constitutional rights that underpin postmodern treaty making. They're not the same legal systems. And not only that, their Supreme Court has reinforced the power of the provinces in a way that the Australian High Court has not. So there are really key differences here. And that structural powerlessness that the Uluru Statement talks to, it's not about elevating deficit discourse and only talking about the negatives. You can't get law reform in this country unless you can identify what the problem is. And it's why the sequencing of the Uluru Statement from the Heart is so critical with the constitutionally enshrined voice as setting up the material and political conditions for agreement making to take place. But it's important to note that there is really important work underway in Victoria under that Victorian treaty process. So to wrap up, the Voice to Parliament is a call for greater political participation in the democratic framework of the state. And it's very common to many liberal democracies of the world with significant Indigenous populations. And look, it's common also to Indigenous peoples in Australia at the Commonwealth level. We have seen many bodies, many committees established, some through legislation, and then abolished at the strike of a pen by the next government. And the problem, you know, is that we are not immune to the vagaries of party politics. And the advocacy for enshrinement is to elevate the voice to Parliament, to elevate our seat at the table above party ideology, above party politics, and above the wheeling and dealing of bureaucrats and public servants and one government to the next. And so that is what is so important about this process. It's one that is aimed at providing the structural support required for First Nations voices to be heard. And 3 years post Uluru, it's desperately needed, you know, from, as I said, from Yukon Gorge to Closing the Gap. You know, Mike Dillon, who is a former advisor to a number of federal ministers on Indigenous affairs and former CEO of the ILC, the Indigenous Land Corporation, and he's now based at ANU, you know, has issued a red flag for the Closing the Gap, new Closing the Gap version 2 iteration. You know, his assessment is that the federal government is stepping back from its post-1967 responsibilities and devolving its responsibilities to the states. He wrote recently that Australia's continued failure to tackle deep-seated Indigenous disadvantage diminishes us all. He says the federal government's ongoing retreat from policy responsibility is driven by short-term politics and doesn't align with the expectations of the Australian people when they voted overwhelmingly in 1967 to give the Commonwealth the power in relation to Aboriginal people. And he said more insidiously is the pretense and the self-deception involved in reassuring ourselves that we are doing all that is possible and that somehow the issues are just intractable and thus insoluble. It undercuts the very integrity of our democratic culture, and this is not a win for public interest. As a nation, we keep aiming for the easy wins. As a nation, we keep signing agreements that kick the can down the road and consign our people to the status quo. A principled human rights approach such as that set out by the Uluru Statement from the Heart would anchor us as a nation to the fulfilment of First Nations rights as agreed to by the world in the General Assembly, in the UN Declaration on the Rights of Indigenous Peoples. And it would embed for us that cardinal principle of the right to self-determination and the right of our people, our First Nations peoples, to be at the table when laws and policies are made about our lives and about our communities. Thank you.
Mr. Davis, again, thank you for a very comprehensive answer. We need to finish now as promptly as we can for a number of reasons. There are questions that have been asked, all of them good, that I can't ask, but I've taken a note of them myself and I'll pursue them in private conversation in other ways. Ben, can I begin by thanking King Wood-Mallesons enormously for hosting this event? I'm sure that you agree with me that you've witnessed a provocative, erudite and current topical address tonight from Professor Davis, of whose work all of us are immensely proud, and who has taken us on a journey tonight and given us the intellectual and the emotional strength to continue on that journey with her. And I don't think I can say any more than that to you, Professor Davis, by way of thanks for the effort that you have taken tonight. And I especially thank you for taking us back into your personal journey with Undrip, a young lawyer so many years ago, learning so much and sharing that with us now. It was a great privilege to be with you tonight. And I thank you on behalf of everybody present, the large numbers, and particularly the Castan Centre and King Wood-Mallesons. We've been together for 10 years or plus, I think, Ben. Hopefully we'll be together for a little while longer. Can I take the liberty to make two small announcements? On the 9th of November, the Castan Centre is co-hosting with Better Governance and Policy, an event on housing, homelessness and human rights in Australia. I hope you can join us. On the 19th of November, we will be launching our report on the use of force in detention and other closed environments. I hope you can join us for that too. Again, Professor Davis, King Wood-Mallesons, thank you. That brings this annual lecture to a close. Bye for now.